My name is Patricia Owens. I am 41 years old. 3 days after my husband left our marriage, I sat in a conference room at a title company with my mother-in-law across the table from me. And when the closing officer read the name on the deed out loud, the room went so quiet that I could hear the air conditioning. I met my husband Gregory when I was 32. He was an only child raised in a household that ran on the particular logic of families where one parent has always had significantly more financial resources than the other. His mother, Beverly, came from money that had been in her family for 2 generations. Not extraordinary wealth, but enough that it had shaped her sense of how the world worked and who had standing in it. Gregory's father had been charming and undisciplined with finances and had died when Gregory was in his mid-20s, leaving Beverly as the sole manager of what remained of the family resources. She had managed them carefully and with a strong sense that they were hers to dispense as she saw fit and withdraw as she saw fit, and that the people who received them should understand the difference between a gift and a loan, which in her understanding was entirely determined by how the recipient subsequently behaved. Gregory and I dated for 2 years. He was thoughtful and even-keeled, and I genuinely loved him in the uncomplicated way you love someone when you are in your early 30s and have enough life experience to recognize something real when you find it. Beverly was a presence from the beginning, not hostile exactly, but calibrating in the way of someone who is deciding over time whether a new person is an asset or a liability to the arrangement they have spent years building. We got engaged after 2 years. Shortly after the engagement, Beverly made a proposal. She had a property, a house that had been in her family for some years, that she was willing to transfer to us as a wedding gift if we wished to live in it. It was a well-maintained house in a good neighborhood, larger than anything Gregory and I could have purchased independently at that stage of our finances, and the offer was framed as a generous gesture from a mother who wanted her son to have a stable foundation for his marriage. What Beverly said at the kitchen table where she made this offer was that she was giving us the house. She used that word, giving. She talked about wanting Gregory to have something permanent, something that would anchor the life he was building, something that reflected the family's history of taking care of its own. What I understood, sitting at that kitchen table, was that we were receiving a gift. What I did not fully register at the time because I was 34 years old and in love and not thinking carefully enough about the legal architecture of what was being proposed was that the word giving and the legal instrument of transfer are two separate things, and that what Beverly said and what she intended and what the paperwork would eventually reflect were not necessarily the same. Gregory handled the transfer with a family attorney Beverly had used for years. I was not closely involved in the legal process. I trusted Gregory to handle it, and I trusted that what Beverly had described was what was being executed. The house was put in our names. We moved in. We lived there for 5 years. The marriage began to deteriorate in the third year in the way that some marriages do, through accumulation rather than crisis. We were not compatible in ways that had not been apparent during dating and the early years, differences in how we handled finances and decisions and conflict that seemed manageable in the beginning and felt structural by year 4. Beverly remained a consistent presence throughout, not dramatically but steadily, in a way that added texture to the incompatibilities rather than smoothing them. She had opinions about the house and how we kept it that she offered with the ease of someone who considered her interest in the property ongoing rather than concluded at the moment of transfer. I had learned by the third year not to raise this with Gregory because the conversations it produced were circular in a way that exhausted both of us without moving anything. We went to counseling, which helped us understand each other better without resolving the underlying incompatibilities. By year 5, we had reached the kind of quiet agreement that exists before one person finally says the thing out loud. Gregory said it out loud on a Tuesday in March. He was calm about it, which I appreciated, and honest in a way that made the conversation easier than it might have been. We both cried somewhat. We agreed to handle the separation as reasonably as we could manage. He moved to a furnished apartment that week, and I stayed in the house while we worked out what came next. Beverly appeared in my driveway the following morning. She was not hysterical. Beverly was never hysterical. She was a woman who expressed herself in a register of precise, controlled statement, and what she stated, standing in my driveway at 8:15 on a Wednesday morning, was that she wanted me to understand something clearly. She said the house was the family's house. She said it had been in her family and she had given it to Gregory, not to me, and that given the circumstances, she expected me to understand that my position in the house was no longer appropriate. She said she hoped we could handle the situation without making things more difficult than they needed to be. I told her I appreciated her coming by. I went inside and made coffee. Then I called my lawyer. I had retained a family law attorney 2 weeks earlier, during the period when Gregory and I were still deciding formally what we had both already decided informally, and I had already had one preliminary conversation with her about the general landscape of what a separation would involve. I had not yet specifically discussed the house because I had assumed it was jointly held and therefore part of a standard marital asset division, and I had not thought to question that assumption because nothing Beverly had ever said about the house had given me reason to. When I described Beverly's visit to my lawyer, she asked me a question I was not expecting. She asked whether I had ever personally reviewed the deed. I said I had not. She said she would like to request a copy of the recorded deed from the county and that we should review it before making any assumptions about the ownership structure. The deed arrived 2 days later. I want to be careful about how I describe what the deed said because the details of property law are specific, and I am not a lawyer, and I do not want to overstate the simplicity of what turned out to be a genuinely complicated document. What I can tell you is that the deed, as recorded, listed my name and Gregory's name together as joint tenants with right of survivorship, which, under the laws of our state, meant that each of us held an equal and undivided interest in the property, that neither of us could dispose of the property without the other's consent, and that if one of us died, the other would inherit the full property automatically. This is a standard ownership structure, but it is not the structure of a gift from a mother to a son. It is the structure of a co-owned marital asset. Whatever Beverly had meant when she said she was giving the house to Gregory, what the legal document reflected was a transfer to both of us equally. My lawyer reviewed the deed carefully and then told me, in the measured way she delivered information, that Beverly's characterization of the situation as the house belonging to the family rather than to me was not supported by the recorded instrument of title. The meeting at the title company was arranged as part of the broader process of working out the marital property settlement. Gregory's attorney had requested it. Beverly came as well, which was unusual and which my lawyer noted with a brief, careful expression that I had learned to read as her registering something significant without commenting on it directly. The closing officer, a man named Thomas, who had been in the title business for what felt like several decades based on the economy of his movements and speech, went through the property in the methodical way title professionals do. He confirmed the address, the legal description, the chain of title, and then he read the names on the current deed into the record. He read my name first. He read it in full, Patricia Ann Owens, because that was the order in which the names appeared on the instrument, alphabetical, which meant my name preceded Gregory's on every document in that chain. The room went quiet. Beverly, sitting across the table with her attorney beside her, said nothing. She had been present at the transfer signing 7 years earlier. She knew what documents had been prepared. I do not know whether she had ever expected the ownership structure to matter in this particular way, whether she had understood what she was signing or believed it was somehow revocable at her discretion, or whether the mythology she had built around the house as a family asset had simply operated at a different level from the legal reality the entire time. What I know is that when Thomas read my name on that deed, she sat very still, and her attorney put a hand briefly on her forearm and nothing that Beverly had said in my driveway 4 days earlier had any bearing on what happened in that room. The settlement process took 4 more months. There were negotiations about the value of the property and how the equity would be divided, which were genuinely complicated and not entirely comfortable. I want to be honest that this was not a situation where the outcome was simple or immediate. Property division in a marriage of 5 years with a house that had entered through a family gift involves real legal complexity, and there were legitimate arguments on Gregory's side about the nature of the transfer and his family's intent that had to be worked through properly. What I can tell you is that I did not leave that settlement process without a fair accounting of my interest in the property. I did not walk away with nothing because a woman stood in my driveway and told me it was not mine. I walked away with what the law said I was entitled to, which turned out to be considerably more than Beverly had suggested I should expect when she appeared in my driveway that Wednesday morning. I moved out of the house 6 months after that title company meeting, once the settlement was finalized and the property was sold and the proceeds were divided in the way the law required. I found an apartment 2 neighborhoods over, smaller, with a parking situation that is genuinely inconvenient, and I have lived there for 3 years now and I am fine. The settlement money went toward a down payment on a condominium I am in the process of purchasing, a place that will be in my name only, which feels like a different relationship with ownership than anything I experienced during those 5 years in Beverly's family house. I have learned things about reading property documents that I did not know before this experience, which is a specific and unglamorous kind of education, but one I would recommend to anyone entering a marriage that involves property coming in from a family member on one side. Understanding what a document says is different from understanding what someone intends, and the gap between those two things is where a great deal of avoidable confusion lives. I have thought about Beverly often in the years since, more with curiosity than bitterness. I think she believed what she said in the driveway. I think the story she told herself about the house, about the family, about what belonged to whom and under what conditions, was a story she had been telling for long enough that it had the feeling of fact to it. That is how mythology works. It does not feel like a story, it feels like the way things are. The way things actually were was on a recorded document at the county office, and it had been there since the week before Gregory and I got married, and no amount of standing in a driveway and stating something with certainty had changed a word of it. Gregory and I did not end the marriage as enemies. We had been honest with each other at the end in a way that made the ending cleaner than it might have been, and I respect him for that, even though the experience of the settlement process around the house was not comfortable for either of us. I do not know what his relationship with Beverly looks like now. That is his life to manage. What I know is that when Beverly stood in my driveway that morning and told me the house was the family's house and not mine, she was speaking from a story she had been living inside for so long she could not see outside it. The story felt true to her. It had the full weight of years behind it. But a story, however old, is not a deed.